Some Republican lawmakers in Tallahassee just rolled out what is essentially a ticking time bomb of a bill that is meant to blow up the state's minimum wage, the state's minimum wage that was approved by the voters of Florida. We're going to tell you about it in just a sec. Hello, and welcome to Seeking Rents, the podcast. I'm your host, Jason Garcia. I am the publisher of Seeking Rents. That's a newsletter in Florida about state politics, but with a particular focus on the ways that big business influences public policy in this state. This is going to be a quick update from day 7 of the Florida legislature's 60-day legislative session. We're basically one full week into the 2025 legislative session down here in Florida. And I want to focus today's show, the bulk of today's show, on one bill in particular that started moving yesterday and is sneaky dangerous, in my opinion. The bill is Senate Bill 676, and it deals with the state minimum wage. And if you're thinking to yourself that nothing good can come of the Florida legislature messing around with the minimum wage, you would be right about that. Let me start by explaining what this legislation would do. It would essentially create new exemptions from the state minimum wage, and it would allow businesses in Florida to pay less than minimum wage to any employee that could be cast as being in some sort of training or learning type of role. And specifically, it says an employer could pay a sub-minimum wage to a worker who is in a structured work study, an internship, pre-apprenticeship or apprenticeship program, or and this is where it gets really broad, any other kind of work-based learning opportunity. Again, so if you could find a way to argue that an employee falls into one of those categories, you could pay them less than minimum wage. And now supporters are going around casting this as like a voluntary thing, like because they're calling it the minimum wage opt-out bill, because the law would require the employee would have to agree to waive their right to the minimum wage in order for this to take effect. They'd have to agree to be paid less than minimum wage, which is on its face is just an absurd idea, as if the power dynamics between a corporation and an individual intern are equal, and they each they have an equal voice in deciding how much that intern is going to be paid. Obviously, the downstream consequences of something like this would be enormous. For one thing, it's just a matter of time before everybody bagging groceries in a Publix is suddenly an intern making less than the minimum wage. It is inevitable that a bunch of big businesses in particular would find all sorts of ways to shoehorn as many employees as possible into these kinds of categories in order to cut their pay. This is the exact same dynamic we've seen play out across the economy, where so many companies are now classifying workers as independent contractors who aren't entitled to any sort of benefits or basic labor protections, rather than employees who would be entitled to that sort of stuff. So the policy itself is just on the face, it's a garbage policy. But what makes this bill so potentially dangerous is that it is unconstitutional, and it is intentionally so. And so this isn't even really like a close call. Let me unpack that just a little bit. So the entire reason that Florida has a state minimum wage, a minimum wage that is higher than the federal minimum wage, is not because of the Florida legislature. In fact, advocates spent years lobbying the Florida legislature, urging the Florida legislature to pass a state minimum wage, partially because I think most people know that the federal minimum wage has sort of fallen way behind over the years. It's failed to keep pace with inflation over the decades, and today it delivers a fraction of the earning power to working families that it did decades ago. But the Florida legislature for years refused to act. It would not adopt a state minimum wage on its own. And that is because so many members of the Florida legislature, including members of both parties, by the way, not it's worse on the Republican side, but there are plenty of Democrats that this is true of as well. They are led around by the nose by the big business lobby, and on issues of wages and hours, not just the big business lobby, but the low wage big business lobby, the tourism and retail industries. We're talking about the folks deciding Florida's wage and hour laws are companies like Disney and Universal Studios, like Outback Steakhouse and Olive Garden, like Publix and Walmart. That's who's making these decisions. So the Florida legislature just refused to create a state minimum wage on its own. And so eventually the voters of Florida took matters into their own hand. And they passed, in 2004, they passed a constitutional amendment by petition drive creating the state minimum wage. This is the same minimum wage that there was another constitutional amendment years later in 2020 that raised the minimum wage more. That's why we're on track towards a $15 an hour minimum wage here in Florida. Yeah. But obviously, everybody who was working on that minimum wage amendment knew that if it passed, that the Florida legislature and the corporate lobby would do everything they could to screw with it. They would try and create loopholes in it. They would try and shrink it. They would try and make sure it covers few carve workers out of it. They would try and ignore it entirely if they could. So the people involved in that game, the folks that wrote this amendment, thought very clearly and put some very ironclad guardrails into the Constitution. So today, the Florida Constitution doesn't just say that doesn't just create a state minimum wage. It also it lays out exactly how that it is to be implemented. And so a couple of points that are particularly relevant to this is first, it says essentially that the Florida minimum wage applies to any worker who is covered by the Federal Fair Labor Standards Act. That's the federal law that establishes the federal minimum wage. And an easier way to say that is any employee, any worker who is entitled to the federal minimum wage is automatically entitled to the Florida minimum wage as well. There's nothing the legislature can do about that. Second, the Constitution also it explicitly gives the power to expand Florida's minimum wage, but it does not give the legislature the power to shrink the minimum wage. So another way to say that is under the Florida Constitution, lawmakers in Florida can expand coverage under the state minimum wage to workers who are not covered by the federal minimum wage. But they cannot reduce coverage under the Florida minimum wage to any workers who are covered by the federal minimum wage. Basically, the Constitution says the legislature can make the state minimum wage better. It cannot make it worse. And the third thing that matters here is there's a provision in there that says if there's any dispute over how to interpret this, about what the legislature can and cannot do, about which employees are covered, all disputes are to follow the federal law and like implementing regulations and case law at the federal level. That's a bureaucratic way of saying if there are disputes at the federal level about whether or not a worker is entitled to the minimum wage, however it gets resolved at the federal level, that flows down to the state level. And that's how it gets resolved at the state level too. And I bring this up. So this is what makes Senate Bill 676 unconstitutional. There is no federal exemption to the federal minimum wage for employees in any kind of work-based learning opportunity. There's a couple of narrow exemptions for like internships and stuff and certain like federal work study programs, but nothing nearly as broad as this. This bill tries to go much further than federal law and create a bunch of new exemptions to Florida's minimum wage that don't exist in federal law. And that is explicitly unconstitutional. And this whole notion that it's an opt-out and that employees can choose to just waive their right to the minimum wage is also unconstitutional. This is actually an issue that has been tested at the federal level. People have tried to do this, and courts have ruled that you cannot waive your right to the minimum wage. You cannot be forced to waive your right to the minimum wage. And think about it. Again, this is a power dynamic thing. If a business comes to you and says, we want you to waive your right to the minimum wage or we're going to fire you, of course you're going to do that. There's not an equal playing field here where you would allow where folks would be able to make sort of free and independent decisions about whether or not they wanted to be paid less money. So the case law is very explicit at the federal level that you cannot opt out of the minimum wage, the federal minimum wage, which means because of the Constitution, you also cannot opt out of the state minimum wage just because Publix leans on you to say you're an intern that doesn't want to get paid wants to get paid a little bit less money, that you intentionally don't have the power to do that for your own good here. And so the sponsors of this bill, they seem to know this. As I said, it is clearly unconstitutional. There's no question about it. So it kind of leads to one of two places. One, this could be just performative chess beat. This could be a couple of mouth breathers that hate the minimum wage and they hate any kind of like government protection for people that they don't think is deserving of protection, and they just want to sort of beat on their chest for a bit and pass a bill or grandstand on a bill that wouldn't actually do anything, but they can sound like big tough guys and maybe do a little sucking up to some of the billionaire funded right-wing think tanks that are always trying to sabotage workers. I don't think that's what's happening in this case. Here's what I think is happening. I think they are trying to tee up a court challenge here, that they want to pass this bill that they know is unconstitutional, knowing that it is going to immediately trigger some sort of legal challenge. Because again, you cannot weaken the state minimum wage. It's in the Constitution. but they're going to tee up that challenge and hope it gets to the Florida Supreme Court that is far more conservative. This is a court that has been completely remade by Governor Ron DeSantis, a politician who is notoriously hostile to the minimum wage, opposed the 2020 minimum wage amendment. They're gambling that the Florida Supreme Court is going to issue some sort of insane ruling that will rip a new loophole in the state minimum wage and start allowing the state of Florida to go backwards on this stuff. And that's what makes this bill so dangerous. Is it is setting up a way for the legislature to claim, for the legislature and the corporate lobby to claim some power to start hollowing out the state minimum wage. So this bill seems to be moving on the fast track too. The House version of this legislation, House Bill 541, is up for its first hearing tomorrow on Wednesday, and I think it's the House Industries and Professional Activities Subcommittee. That's a sexy committee name if ever there was one. So, but this bill is moving. But this is one to pay attention to and one to call out for the potential damage it could do long term to workers across Florida. The irony of the Florida legislature spending time yesterday trying to screw with the citizen passed minimum wage constitutional amendment was at the very same time the Senate's Ethics and Elections Committee was also working on a bill to obliterate the whole petition drive process entirely. I think we've done two of these daily shows already, and both times we focused pretty heavily on the effort in Tallahassee to shut down the citizens initiative process. So I won't go too far into it, but the Senate Ethics and Elections Committee yesterday passed Senate Bill 7016, which is the Senate's version of the bill that's essentially meant to make it far, far harder to run a petition drive for a constitutional amendment. The House bill is already moving. It may end up moving again later this week. We haven't gotten agendas yet for Thursday. The Senate bill is actually even worse than the House bill. That said, there was a little bit of good news, so I want to shout this out. The bill was changed, the Senate bill. This is, again, Senate Bill 7016. And as I mentioned, we'll throw links to all the bills into the show notes, so you can go look up more on them if you want. But they did stick an amendment on there that would actually prohibit public funds from being used on public service announcements masquerading as political advertisements. Exactly what we saw the DeSantis administration do this past fall, where they dumped, we still don't know the exact number, but I've estimated like more than 20 or something like $20 million in taxpayer money paid out of 5 state agencies towards advertisements essentially against Amendment 3, which would have legalized recreational marijuana in Florida, and Amendment 4, which would have overturned a statewide abortion ban. Both amendments got more than 55% of the vote, but they fell just short of the 60% supermajority that Florida requires, which is, as we've said before, by the way, a legacy of that original minimum wage amendment in 2004. The big business lobby was so pissed that it happened, they got the legislature to stick an amendment on the ballot in 2006, raising the threshold to pass future constitutional amendments to 60%. Irony of all ironies, the 60% amendment passed with less than 60% support, but that's the world we live in. Anyway, Senate Bill 7016, as awful as it is, they stuck this amendment onto the bill that should prohibit the DeSantis administration from doing something like this again, from spending taxpayer money on what are essentially political campaign ads masquerading as public service announcements. And I want to give credit where credit is due. This came from a Republican, Senator Jennifer Bradley, a Republican from kind of near the Jacksonville area. She's the one that offered this amendment, and ultimately this was Republicans on the Senate Ethics and Elections Commission agreed to put this onto the bill. So this is still an awful, awful bill. This is, if you've ever heard the expression turd in a punch bowl, this is more like we got a little bit of punch in a turd bowl here. It'd still be nice to just throw the whole thing away. But this is a positive development. I think it's actually one that I was just like complaining about in my newsletter on over the weekend about. So the behavior we saw to the DeSantis administration was unprecedented. We've never seen a governor use their official powers to interfere in election campaigns this way and to dump so much taxpayer money advertising against amendments that we now know were supported by strong majorities of voters. That should never have happened. It should absolutely never happen again. I will say about this, sometimes it's difficult to tell early in session when good things happen, whether or not it's a good faith effort to stop some bad policy or pass some proactively good policy, or whether it's a distraction meant to sort of like take a little bit of heat off or make a bill a little easier to move. And then we've seen so many times in the past where something positive happens in week 1 or 2 of session and then gets undone on day 60. And the worst version of what we feared is what actually ends up passing. So I have no way to know if this is a good faith effort to rein in the DeSantis administration and at least ensure we won't be supporters of constitutional amendments won't be dealing with a government with an unlimited advertising budget, sort of blanketing the airways with ads against them, or if this is just a distraction meant to get a few headlines focused on this rather than the kind of the grotesque stuff this bill, the broader Senate Bill 7016 does to the petition process, which, by the way, essentially puts all sorts of restrictions on people's ability to voluntarily collect petitions. It's an awful bill. But all that said, if this is a good faith effort to rein in this stuff, I think it's important that we all be thinking about making sure this is enforceable. So it is not hard to imagine, even if this passed, that given his history, that Ron DeSantis would simply ignore this, spend a bunch of money if Medicaid expansion, that's an amendment that's on the ballot right now, or that folks are gathering signatures for now. If a Medicaid expansion measure was on the ballot, it's not hard to imagine Ron DeSantis just simply ignoring this law and having like the Department of Health dump millions of dollars into ads trying to explain to people why it would be so awful if more people had health insurance. And just sort of bet that no court was going to hold him accountable. We've seen this so many times in the past, including in these Amendment 3 and Amendment 4 campaigns, where people try and enforce existing laws, they sue, and then courts essentially defend Ron DeSantis by finding some reason to not get involved, by denying standing or claiming they're powerless to intervene themselves. So if this is a good faith effort, it needs to be made very clear who has standing to sue to enforce this. So there's no dispute about whether or not courts get involved. And I would argue there probably ought to be some like real severe penalties for the governor or any agency head who interferes with this. We're going to throw like $50,000 fines at people that like accidentally collect a petition that they weren't allowed to collect or something like that. How about a $50,000 fine for the governor if he's caught breaking the law on illegal campaign advertising here? So as this bill moves forward, stipulated, I hope the bill dies and burns a fiery death and never passes to begin with. But if this bill moves forward and we do have this good provision added to it, I hope there's some real thought spent on making sure it's actually enforceable and that this isn't just a little bit of window dressing that won't actually have any impact. Because again, wherever you stand on any constitutional amendment, you should not want your government advertising for or against it. You don't want propaganda coming out of the state trying to tell you how to vote on a bill. That's a decision you can make yourself, and these are arguments that the advocates for either side of an issue can make themselves. So I'm going to just real quick mention one last bill that I just kind of learned about yesterday while I was looking through things. So a bill that moved forward yesterday is Senate Bill 1624, a bill dealing with the state's higher ed system. And this is a big higher ed package. But the reason I flag it is it's got this like little provision in it that continues kind of the explicit conservatization, however you want to say that, of Florida's schools. And specifically, Florida has a program called the Preeminent State Research University Program. This is like essentially schools that meet a bunch of like high performance benchmarks in terms of like the quality of admitted students, the amount they spend on research, all these kind of quality metrics. If they hit enough of them, they essentially get labeled preeminent research universities, and they become, among other things, eligible for a bunch of extra funding from the state. This bill would add to the metrics that could be used about whether or not you qualify for this extra funding, test scores on the classic learning test. This is one of these like explicitly conservative, very sort of Christian overtoned admissions tests that conservatives have been pushing as an alternative to like the SAT and the ACT and stuff. And Florida has been, of course, at the front of this movement in terms of allowing the classic learning test to be used as an entrance exam. And now we're going to start even using it as a metric for what our best or most academically rigorous universities are. So it's just another one of those examples of you can have these big bills moving that you have no idea what's in them, except it turns out like deep inside them is a little bit more sort of indoctrination is tucked inside a bill that might look benign otherwise. So anyway, I'm going to leave it there. We will be back again tomorrow. We got some really sort of tacky bills on tap today, including the state's agriculture commissioner is going to go to war on plant-based milk and apparently thinks Floridians are too stupid to understand that oat milk does not come from a cow's udder. So that bill's on tap, and then we got some pretty ugly bills coming on Wednesday as well. So we'll be back tomorrow with more on those. And until then, thanks for listening, and talk again soon. Actually, it occurs to me that I didn't throw the plug on there, so I'm gonna say that again. Anyway, we'll have more on those bills and others tomorrow. In the meantime, just as a quick reminder, if you are watching this on YouTube, please make sure to click like and subscribe. And if you got any comments about any of the bills we've talked about or anything else the legislature is working on, make sure leave a comment below. And then if you're listening to this on a podcast catcher of any kind, just subscribe to the show, maybe leave a review if you can. And then if you haven't already, sign up for the newsletter. Easiest way to find us is at seekingrentsfl.com. Subscriptions are free. None of our stories or podcasts are behind a paywall, but there is an option to voluntarily pay for a subscription if you can afford one. If you got the means, please think about doing it. The revenue we get from voluntary paid subscriptions are really helpful to covering reporting expenses like public records requests. Okay, we'll be back again tomorrow. Take care.